uh, Dean Elizabeth Magill. She's our moderator for the panel on oversight and accountability. Dean Magill is the Richard E. Lang Professor of Law here at Stanford Law School, and she's about to end her second year at the helm of Stanford. She joined us from UVA, where she was vice dean, and she's a scholar in administrative law and constitutional law. Right after college at Yale, she was on the Hill for about 4 years, I believe, as a legislative assistant to Senator Kent Conrad. So, as you know, we've been talking about congressional oversight and oversight generally. So, I can't think of anybody else who would be better suited to moderate this panel. She clerked for Judge Harvey Wilkinson in the Fourth Circuit and Justice Ruth Bader Ginsburg in the Supreme Court. So, thank you, Dean Magill.
Well, thanks everyone for being here. I have not been able to see a lot of the panels. I've been told by several of you that what's continuously come up is oversight and what we're going to talk about in this panel. I was particularly pleased to be asked to moderate this panel because I actually have no expertise in the substance here, but the work that I have done as an academic has focused on the fact that if you are inside either Congress or the executive branch, you will understand that it is not unitary in any way whatsoever. And I think this panel gives us some sense of the complexity of the different roles of actors in this national security state and the roles that they play. So I'm particularly delighted. We have an incredible panel here today, and I was rereading everybody's biography this morning and feeling that we are just privileged that these four people have come to talk with us today about oversight and accountability. I'm going to introduce them first, and then each of them will speak. We'll try to have them speak for about 7 or so minutes, and then open it up to conversation between and among the panelists and also to the audience. So Judge Carr is joining us. Judge Carr is a federal district judge in the Northern District of Ohio. He joined that court in 1994 after being nominated by President Clinton and confirmed by the Senate. He was chief judge of that court from 2004 to 2010 when he took senior status. Relevant to the panel today, from 2002 to 2008, Judge Carr served on the FISA court, I think you've heard of it, the United States Foreign Intelligence Surveillance Court in Washington. He's a 1962 graduate of Kenyon and a graduate of a school in Cambridge, Massachusetts. Before he went to the bench, he was an academic, and he's done a lot of...
EDS, Episcopal Divinity School.
Yes, exactly. He was an academic, and he's an author of many books and articles, including a treatise on electronic surveillance law. Glenn Fine is also with us. He's now a partner at a Washington, D.C. law firm. His practice focuses on a variety of things, including internal investigations, corporate compliance issues, government investigations, and global white-collar and securities matters. After serving in the Department of Justice's Inspector General's office for 5 years, Mr. Fine was nominated by the President and confirmed by the Senate as the Inspector General of the U.S. Department of Justice, and he served in that capacity from December 2000 to January 2011. As the Inspector General at DOJ, he supervised 400 employees. They conducted a variety of investigations, among them some of the most high-profile investigations you will no doubt remember: the Justice Department's handling of intelligence information related to the September 11th attacks, the Department's treatment of detainees after September 11th, allegations regarding politicized hiring of the Department of Justice and the firing of U.S. attorneys, and the FBI's use of national security letters. From 1989 to 1994, this is before he went into the Justice Department, he was also in private practice, focusing on labor and employment law. Before that, he was an assistant United States attorney in Washington, and he prosecuted a wide variety of criminal cases there, having many jury trials. Mr. Fine was a Rhodes Scholar. He was co-captain of his basketball team at Harvard, and he was drafted by the San Antonio Spurs. My first question for him today was whether he played, but he did not play. Jeremy Lin, graduate of Palo Alto High School, has taken away one of his best lines, which is, when would you have imagined a Harvard point guard would play in the NBA? So we're sorry that Jeremy has taken away that great line. Professor Carrie Cordero comes to us from Georgetown University. She joined Georgetown as the first director of the National Security Studies program there. Before that, she had a decade at the Department of Justice in an amazing number of positions related exactly to national security policy, operational matters in the DOJ. Among other things, she was the counsel to the Assistant Attorney General for National Security. In that capacity, she provided advice on the National Security Act, the Patriot Act, other relevant laws and executive orders related to national security. She also served as chair of an interagency group established by the Director of National Intelligence to improve the processes related to the FISA court. Prior to that assignment, Professor Cordero served in a joint duty capacity as the Senior Associate General Counsel at the Office of the Director of National Intelligence, where she worked on legislation, implementation, and oversight related to significant amendments to FISA itself, the Act. We also have with us Dr. George Ellard, who is presently the Inspector General of the National Security Agency, a capacity he has served in since 2007. He brought to that post a lot of experience in the practice of law as a federal prosecutor, as a criminal defense counsel, and as a civil litigator. Before becoming the Inspector General, Dr. Ellard headed the criminal practice of a large Washington, D.C. law firm. He had, in addition to his private practice, extensive government experience. He was counsel to the congressional inquiry into the terrorist attacks of September 11th. He was responsible for drafting classified and public reports that recommended transformational changes in the structure of the intelligence and law enforcement communities. Dr. Ellard also served as chief of staff to the Presidential Commission that examined U.S. counterintelligence programs in the wake of the most damaging espionage episode in United States history, that is the one perpetrated by senior FBI official Robert Hansen. He was also chief counsel to a senior U.S. senator and counsel to the Senate Judiciary Committee on Crime. Dr. Ellard received his degree in law from a school in New Haven, as well as a PhD in philosophy from Yale, where he was articles editor of the Yale Law Journal. So we have an amazing panel who can address the issues of this conference that I gather have been in the backdrop of many of the panel's oversight and accountability in this space. So we're going to start with Judge Carr, then Mr. Fine, then Professor Cordero, and then Dr. Ellard. Judge Carr, thank you for being with us.
I'm actually here, I believe, because last summer in July, I had the audacity and good fortune to have an op-ed published in which I made a proposal, I think a very modest proposal, which I have since kind of, in my own mind, have expanded some of the things that I think would meet the caption that the Times gave it, toward a better secret court. The proposal is quite simply this. It's something I thought of when I was serving on that court, and that is from time to time, very rarely and frequently, I felt the desire as a judge to have an attorney other than just the Justice Department attorney appearing in front of me, despite the confidence I had in the department and the agencies nonetheless. And that was a situation that would arise when there was something new or novel in the application. The government at the time was a very honest broker. They would come in and say, Judge, or to the court, our legal advisors in the court, better take a look at paragraph 64 to 82. It's a new technique, it's a new method, it's a new whatever, it's a new interpretation of the law. And it was in instances like that I felt, gee, I wish I had somebody who could come in and represent the interests of the public, the target, the Constitution. And that did not exist. And that was basically my proposal, was simply give the judges discretion. I've since thought about that a bit. And one thing I want to say by way of segue, you've heard a lot about opinions of the court. Let's back up and put this whole process in context. This is like issuing a search warrant. I'm sorry, I've got a call. No. This is like a search warrant or Title III application. They never get turned down. The reason for that is the government shows probable cause. And of the what? They said 1,700 applications. I would suspect, I don't know, probably 1,690 of those to 95 were straightforward issues of probable cause. Is the target affiliated, working for, or representative of a foreign government? or on the other hand, is a target a member of, affiliated with, or working on behalf of a foreign-based terrorist organization. That's all they have to show. They do not have to show the need for the surveillance they do with the Title III order. It is simply, that is a very low standard of probable cause, and the government shows it case in and case out. Those instances that generate opinions are those that in which the government has, pursuant to Rule 11, and I just looked it up to check it, of the Foreign Intelligence Surveillance Court Rules of Procedure, and actually I wrote the first iteration of these rules and included that, require the government to notify the court. The caption is, notice and briefing of novel issues. If submission by the government for court action involves an issue not previously presented to the court, including but not limited to a novel issue of technology or law, the government must inform the court in writing of the nature and significance of that issue. And it says B, submission relating to new techniques, and it lists what the government has to do in terms of describing and telling the judge what the new technique is and how it's going to be implemented. And my own thoughts have evolved. It seems to me that there ought to be a Rule 11 trigger, that Congress can do this. It's statutorily, I think, very easy thing to do to amend FISA, that when the government provides Rule 11 notice, which it does, I have no doubt about that for the reasons of candor and relationship that I mentioned earlier this afternoon. Rule 11 trigger, outside lawyer comes in, pre-cleared security, already has a security clearance, and then responds to the application. There would be times when the lawyer might say, look, I have nothing really to say. It's perfectly all right. The lawyer might say, object. It would do a couple of things. First of all, it would give the judge a better basis of information and give us a greater comfort when we're dealing out there with a PRISM type situation or whatever. Secondly, it would provide the ability that does not presently exist when the government wins, when the government persuades the FISA court that it should go ahead and do this, there's nobody to appeal. By having a lawyer in there from the outset, on a very infrequent number of occasions, I want to emphasize that, then that would provide the basis for appellate review, which of course is what keeps judges honest when you get right down to it. Try as hard as we do to be honest, nonetheless, appellate review plays a very important role. So that's the first sort of change. Secondly, and by the way, it occurred to me listening to the papers this morning, the court now has en banc authority. It did not have en banc authority. I don't know whether it's ever met en banc, but maybe what Congress should do is, with the Rule 11 notice, new and novel, maybe that should be presented at the court en banc. I think all of us would have greater confidence instead of it was just one judge, at least a majority of the 11 judges who serve in that court agreed with the government or the majority disagreed. But in any event, rather than single judge by single judge, and even though we would get prior opinions, nonetheless, and they're non-precedential, there have been instances where one judge has allowed something and 90 days later the renewal comes before a different judge, that judge has not allowed it. But in any event, I think the en banc would be very important. In addition, with regard to the publication of opinions, it seems to me that, again, the Rule 11 should be the trigger. That's the only time, almost, that you write an opinion while serving on that court. You don't write opinions issuing Title III order. You don't write opinions issuing a search warrant. Maybe once in a while there might be something about a First Amendment overlay with a Fourth Amendment issue under FISA. You write an opinion without this new or novel. But what we're talking about is when there's something new and novel presented to the court. And it seems to me that, again, the default ought to be whenever the court writes an opinion, the government is called upon to show cause why it should not be published in a whole or part. Give it, no, you don't, give it 2 weeks or whatever. But that also, if there's a lawyer already in the case, then that lawyer can speak to that issue. If a lawyer isn't, get a lawyer. Perhaps even you might want to think about having a cadre of First Amendment lawyers. I don't know. I'm more focused on the idea of lawyers who have a national security law background who would be called upon on occasion, as I've indicated. You don't need, as Senator Blumenthal has proposed in legislation, a brand new agency that vets every FISA application. It'd be a colossal waste of time, effort, and money. The job that I think needs to be done could be handled by a small, you have a small list, maybe a dozen or so pre-cleared lawyers. And then I'm getting kicked off the panel. So I learned these things while I was sitting here this morning. And one final thing. Oh yeah. And then finally, with the Title III, we have periodic progress reports. I issue a law enforcement wiretap. I meet with them every Monday morning, case agent, prosecutor, on the record. It occurs to me, we could do the same thing in the FISA court. We've never done it, I don't believe, because we sit once for a week or so, a little less, on a rotating basis, and the orders come up for renewal. We rarely see a renewal of an order that we had. But again, I think the presiding judge could designate, courts met en banc, Rule 11 trigger, designates a judge who then periodically would return to Washington, where all this work is done, and review the implementation, whether it's a prison program or anything else of the sort that was covered under that rule.
You are not being kicked off the panel.
No. I thought I did. I tried to say it within time. Sorry if I didn't.
You did.
My apologies.
Mr. Fine.
Well, first, Dean Magill, thank you for that kind introduction. Before I start talking about the role of inspectors general, which is my topic, I need to address the basketball issue.
Okay.
Most people, when they see me, when they heard that I was drafted by the San Antonio Spurs, which is true, they think it's not possible. I'm too small. I'm 5'9". It didn't happen. Well, it actually did happen. But now I've gotten to tell people, before I started the job as the inspector general, I was 6'9". And actually, the last time I was on the Stanford campus was when Harvard played Stanford in basketball when I was in college, and I was on the team.
Who won?
And Stanford beat Harvard handily. Oh. And I have vivid memories of tall Stanford players swatting away my shots. So hopefully this will be a more pleasant experience this afternoon. I'm sure it will be. I am glad to talk about one of my favorite subjects, the role and importance of inspectors general in overseeing agencies, including intelligence agencies. And let me give you a brief background about inspectors general. There are inspectors general in pretty much every federal agency, about 70 of them. They, in the large federal agencies, the cabinet agencies like the Department of Justice, they're appointed by the President and confirmed by the Senate. In other agencies, they're appointed by the agency head. They're appointed for their nonpartisan qualifications. They're not tied to one side or the other. And they report to both the agency head and to Congress. There's a dual reporting requirement. The stated role of an inspector general is to detect and deter waste, fraud, and abuse, and to promote the economy and efficiency of the agency. It's an interesting entity. We're within the agency, and our job is to critique the agency, make the agency perform better, and to provide some measure of transparency on how the agency is run. And in the Department of Justice, we had 400 employees to do that: auditors, inspectors, investigators, lawyers. That may sound like a lot of people for that role, but the Department of Justice is huge. It has 110,000 employees, and it has about a $30 billion budget each year. It includes the FBI, the DEA, the Marshal Service, the Bureau of Prisons, the ATF, litigating attorneys in Maine Justice, U.S. attorneys. So it's a big operation, and it's quite a task to oversee those agencies. The powers of inspectors general are pretty significant, however. We have access to all records of the agency, and we have subpoena power for all documents outside the agency as well. All agency employees must cooperate with the inspector general or face disciplinary action. We have the power, actually arrest power in criminal matters in the Department of Justice Inspector General and in other inspector general's offices. We can pick any review, any case we want to investigate, and the head of the agency can't stop us from doing so, except in very narrow circumstances, and it's been rarely used to do that. Our role is to critique and make recommendations for improvement. The agency does not have to accept the recommendations, but it has to respond to those recommendations, whether it will accept them or won't accept them. As you can imagine, with these responsibilities and these duties, you're not always the most popular person. And I always said I was not the most popular person in the Department of Justice cafeteria. Sometimes we've been likened to the skunk at the picnic. And I will tell you a story. When I first became the Inspector General, I went up to brief a senator about one of our reports, and it was a senator who was very interested in IG issues. And I brought along with me my longtime deputy, terrific guy named Paul Martin. And so we briefed the senator about our report, and he accepted the briefing and then said, I want to tell you about the role of an inspector general. You have to be independent. You're going to do things that I'm not going to like. You're going to do things that Congress is not going to like. You're going to do things that the Attorney General is not going to like. You're not going to be liked. Nobody's going to like you. You won't be liked, so don't expect to be liked. Nobody's going to be liked. He kept saying that again and again. Nobody will like you. And finally, my deputy, who had heard enough, terrific guy, said, oh, don't worry, Senator, even I don't like him. which cracked the senator up, and that was the end of the story. But it's an important point. We're not there to be popular. We're there to do the job aggressively, and not to worry about whether we're liked, whether we're popular, what the view of us in the department is, but to try and help improve the Department of Justice operations and other agency operations, and that includes intelligence matters. And in terms of being popular, we're always critiqued for being too hard or too soft. We're either a lapdog or a junkyard dog. We're on a whitewash or a witch hunt. You're never going to allow everybody to appreciate what you do or like what you do, but your job is to do it in the best way possible and to make recommendations and to help improve the operations of the department. When the department changed after the 9/11 attacks and became, their top priority was counterterrorism and counterintelligence, our job changed as well. So we focus on what's important in the department and what are the significant issues of the department. And as a result, we did a whole series of national security investigations that had very significant national security implication. And some of them were mentioned, starting with the treatment of detainees in the investigation conducted by the FBI as a result of the September 11th attacks, and found very significant problems with how they were treated and the way the investigation was conducted. We looked into what the FBI knew, what intelligence information it had prior to the September 11th attacks, and found that there were missed opportunities with regard to that intelligence information. We didn't say that they necessarily would have stopped the attacks, but we did find missed intelligence opportunities. We did a review of what the FBI knew about the Robert Hanssen matter, the most damaging spy in FBI history, and why was it that it took 2 decades for the FBI to catch a spy in its midst. We did a review of national security letters, types of administrative subpoenas that the FBI can use to get very sensitive information about individuals, financial information and other information, and found that there were significant abuses in the use of those letters. We did, along with other intelligence community IGs, including Dr. Ellard, a review of the President's surveillance program and what went on with that, including a review of the infamous hospital scene where the White House tried to get the Attorney General Ashcroft, and his deputy, James Comey, who's now the FBI director, to recertify an aspect of the program that they believed was illegal. Not all the reports we do are critical. We often exonerate people, including our review about what the FBI witnessed at Guantanamo, where we found that they abided by FBI procedures and did not engage in enhanced interrogation techniques or anything that was improper according to FBI procedures. So our role, as I stated, was to help improve the operation, to expose both the good and the bad, and to ensure that the agency know that someone is watching over them, someone to hold them accountable, and someone to provide some measure of transparency on what it's doing, including in intelligence matters. And I'd be happy to answer any questions anybody has about that, but I do believe that the role of the Inspector General is a critically important one within federal agencies. Thank you.
Thank you.
Okay, great. Thank you. And thank you, Dean Magill, for hosting this conference and for inviting me to participate with these distinguished co-panelists today. So I'm going to try to tie together a little bit of some of the streams that you've started to hear from Judge Carr in discussing a little bit about the FISA court oversight role, and then sort of the broad picture that Glenn has provided of the role of IGs. And I'd like to focus specifically, I'm going to focus specifically on the oversight and accountability that's involved in implementing the Foreign Intelligence Surveillance Act, or FISA. And even more specifically, I'm going to try to spend part of my 6 minutes and 45 seconds left on the implementation and oversight that exists in Section 702 of FISA, because that has really been one of the key pieces that has been under public discussion for the past year. And so I think that might be helpful. My understanding is that the 702 piece, which is That's the provision of FISA that was added in 2008 by the FISA Amendments Act that allows for the targeting of non-U.S. persons reasonably believed to be outside the United States, and this is content collection. So different than the phone records program that you've heard about. The 702 program is content collection. So I want to describe a little bit about that oversight, which really is covered by all three branches of government. And at the 30,000-foot level, what I'm going to suggest to you is that the oversight of FISA activities in general and the Section 702, this overseas content piece particularly, is probably the most oversight-laden intelligence activities in the history of the planet. And I'm going to try to quickly sort of go through and make that case and explain why. So first of all, there are a comprehensive and complementary set of laws and executive orders that and internal procedures and operating procedures that govern these types of activities. There are reporting requirements, written reports, internal executive branch reporting requirements that go to the FISA court, reports that go to different oversight boards, reports that go to the Intelligence and the Judiciary Committees of Congress. And then third, in addition to sort of the legal structure, the reporting requirements, there are many, many briefings that take place. So there are briefings for internal executive branch leadership. There are briefings that occur for White House leadership or other agencies outside of the collecting agencies. And there are many briefings provided to congressional members and staff. And so it's fair to say that the oversight structure of FISA generally involves hundreds of people, including lawyers, analysts, auditors, senior management, folks like personnel in the inspectors general's offices, judges, legal advisors, and congressional members and staff. There are many, many people and components involved in the oversight process. With respect to this Section 702 oversight, which has been part of the programs that have been discussed so much in the past 10 months or so, there are sort of three categories of oversight and accountability that take place on these activities. First, there's the internal oversight that takes place within the collecting agency. So this involves supervisory levels that approve targeting decisions. It involves a role for the Office of General Counsel, a role for Office of Compliance within NSA, for example. NSA now has a Civil Liberties and Protection Officer. And then there's the role of the Inspector Generals, which Dr. Ellard will talk about in a few minutes. So that's only within, those are sort of the different levels and offices and components involved just within the collecting agency. The next tier is outside of the collecting agency, but still within the executive branch. So a very involved agency that's involved in this oversight is the Department of Justice, and in particular the National Security Division, which is the office that I came up through for years in government. And this office within the National Security Division has an office of oversight, and those lawyers are involved in the oversight of the 702 collection to the detailed degree that they actually review targeting decisions, they review intelligence reports that are issued from this collection, and they review to ensure that both the targeting decisions and the reports that are written are conducted in accordance with the targeting procedures and minimization procedures that are approved by the FISA court under Section 702. Now, just minimization is a term of art, which is defined in the FISA statute, and it concerns the procedures or the rules by which the handling agency acquires, retains, and disseminates foreign intelligence information that's acquired during the collection. So how information is minimized and how, in particular, U.S. person, information about U.S. persons is handled falls under the implementation of the minimization procedures. In addition to the DOJ rule, the Director of National Intelligence, so this conference has had quite a few people who have been part of the Office of Director of National Intelligence, which was established by law in 2004. And so since its creation, the DNI has taken a very active role. The Civil Liberties Protection Officer and the Office of General Counsel at the DNI are very involved in the oversight of this 702 collection in particular. In addition, you're going to hear on the next panel from a member of the Privacy Civil Liberties Oversight Board, which also is conducting a review of the 702 program. With respect to the specific reviews that are done of the 702 program by the Department of Justice and the DNI, these are very, as I mentioned, they're very detailed reviews. Since the disclosures of this past summer, in August of 2013, the DNI declassified one of the joint assessments, as they're called. So these are reports that are issued jointly by the AG, the Attorney General, and the Director of National Intelligence. Previously, these reports were provided within government and they were sent to the Congressional Oversight Committees. But the August 2013 report has now, a report was declassified in August 2013, which is now publicly available. And just to give you a sense of sort of what comes out of that report, according to that joint assessment, NSA's rate of noncompliance with the 702 rules and procedures that I described is less than 0.5%. So it came down to about 49%. Now, to clarify what that means even further, 0.49%. Thank you. Yes, less than one half. I said it in the words right, but I got the statistic wrong. Less than 0.5%. To be clear. Okay. Just to drill down that a little bit, the rules under which the agency structures, one of the compliance procedures is that NSA has to self-report to the Department of Justice and to the DNI incidents of noncompliance. And they have to do it within a certain time frame. If you take away those types of what turn out to be called compliance incidents, but basically these delays in reporting requirements. So let's say they're supposed to report within I don't remember what the actual number is. If they're supposed to report within 1 day and they report on the second day or the third day, that would actually count. If you take away those types of reporting errors, the rate from this August 2013 report comes down to 0.15 to 0.25% rate of error. So we're talking about a really minuscule rate of error that's the result of these reviews. So that just gives you a very small taste of the granular level of oversight of this FISA Section 702 section that's conducted by the Department of Justice and the DNI. In addition to that reviews, we have the oversight that's conducted by the court. And as a former Justice Department attorney who appeared before Judge Carr and his colleagues, I can tell you that these are sitting federal district court judges who do what federal sitting court judges do. And they can request additional information, request additional witnesses, ask for more information, require that a matter be returned to them if they want to sort of keep tabs on what's going on in a particular case. And they can and do all of these things in the conduct of their activities. And finally, there's the congressional oversight. So I'll stop there, and maybe as the discussion continues, we can raise sort of a few questions about whether the oversight that we're all discussing here is sort of calibrated right and is effective.
Let me say, I'm sorry, but she neglected to mention the fact that also by rule of the Foreign Intelligence Surveillance Court, the agency and the department are to report to the court on any instances of noncompliance.
Yes.
And that also codified prior procedure.
Dr. Ellard.
Thank you. I was going to say what Glenn Fine and Professor Cordero said. So while I scramble to change my thoughts, I'd like to begin by referring to what might at first not seem to be on point. But by the end of my presentation, I hope to show you how it is. And that is to some remarks that Dean Parker and Judge Carr made about the agency. When I came to the agency 7 years ago, I too shared the prejudices, if you want to call that, of a different era. For example, my involvement with the military before I joined the NSA was limited to National Guardsmen pointing their bayonets at me some decades ago. So I too had a very skeptical attitude when I came. The NSA is an amazing place. What it does to protect United States security is astounding in itself, but it's also amazing because of the people there. And I'm going to limit my initial remarks to the members of the military. I was astounded when I began to see that this is an institution based on civic virtue. For instance, patriotism, dedication to mission. It's a truly astonishing group of people. And by the way, obedience to the Constitution. So I was amazed when so many people in the recent past came to look at the NSA as a lawless leviathan, which was engaged in a conspiracy to violate the fundamental constitutional rights of the United States people. That simply is not true. And it's not true for many reasons, one of which is that the NSA, I believe, is the most toughly, most, what would you say, highly regulated entity in the world. It's overseen by three branches of the government, the executive, the congressional, judiciary, and by a very, very stern and strict internal system of review, multi-layered. What I'm going to try to do in my brief time left is to put together what all of these people have said, to give you some notion of the composite nature of the oversight performed in, by, and on the NSA. Professor Cordero talked about Section 702 of the Patriot Act of FISA. I'd like to briefly look at Section 215 of the Patriot Act. That's the NSA program that has gotten so much adverse press in the recent past. That's the so-called business records or metadata program, in which we collect certain information about a whole lot of telephone exchanges. Now, this program is administered under the law. Obviously, that means it was something enacted by the Congress and signed into law by the President. Before we can do anything under the Act, as Judge Carr pointed out, we have to, before we can do any acquisition, we have to obtain from the FISA court an order. And that order has to be reapproved, re-examined, and reapproved approximately every 90 days. Now, since the first order was issued in 2006, that particular order has been re-examined 37 times by 16 different federal judges. In order to implement those orders, in order to have access to the information I just spoke about, the NSA has to demonstrate to the satisfaction of the FISC court that we have, and this is something I have a terribly difficult time saying, we have a reasonable, articulable suspicion that the information we're going after is associated with a specified terrorist organization. And we can use that 215 program for nothing other than that. Minimization procedures, already explained. I won't go over them again, but they're designed to protect U.S. person information. In the normal case, if we discover we have it, we have to delete it. In the extraordinary case, we have to follow procedures, first of all developed by the Attorney General, and secondly approved and made part of the FISC orders. DOJ, as Professor Cordero said, the National Security Division, participates with NSA attorneys and the NSA Inspector General to review the compliance of the agencies with these court orders, and they're done, that is done, I believe, every 90 days. Quarterly, the Inspector General has to create a document which is co-signed by the director of the NSA and by its general counsel about NSA's compliance with all the many laws and regulations and policies which govern it. And that review is sent, again quarterly, to the President's Intelligence Oversight Board. And we reveal everything that is not in compliance with laws and regulations. We also are subjected, again, as was said, to scrutiny, and it is rigid scrutiny, by the Office of the Director of National Intelligence, by the Assistant to the Secretary of Defense for Intelligence Oversight. Our OGC has a component dedicated to intelligence law, and in large part, that's compliance law, intelligence oversight, we call it. OGC attorneys are embedded in all the principal directorates in the NSA. This was something which struck me greatly when I came there, and I began to wonder about the degree to which attorneys are making tactical decisions for the NSA. And I came to refer to that as the tyranny of the lawyers. Each of our major directorates has within it a compliance unit that is local strict scrutiny over just about each and every transaction an analyst or collector will make. And we recently developed an automated tool so that as they happen, these compliance incidents get reported to the OIG, both in real time and in the quarterly compilation. We also have the Office of Inspector General, which has a division called Intelligence Oversight, in other words, compliance. And we are the only IG within the intelligence community to have an office dedicated simply to that. And what we do is periodically and regularly examine those NSA programs that we believe to be at greatest risk for noncompliance. And we examine and test the controls that the agency has put into effect in order to ensure compliance. And as was pointed out, we can be and are supposed to be very, very critical. We report, the OIG that is, directly to the director and directly to the intelligence oversight committees in the Congress, as well as the judiciary committees. As I said, we also report to the President's Intelligence Oversight Board and to the Office of the Director of National Intelligence. It's not simply, though, this massive structure that's laid upon NSA's activities. It's the people themselves. They are, from the very first day, the very first thing you hear when you raise your hand and swear to abide by the Constitution, is that the Congress and the United States people had given the National Security Agency tremendous powers. And with that power comes a responsibility. You are told the very first thing to abide by the law, and in particular, to abide by the Constitution. And you are trained from your very first day. And it becomes almost oppressive because you have to take course after course after course annually. And most of those courses have to do with compliance. So this is built into those people. And those people already bring with them, I assert to you, a dedication to the country and a dedication to the Constitution. And finally, there was one other tool that I bet you haven't thought about, and that is the polygraph. We are subject to regular polygraphic examinations. And I dealt frequently with polygraphs when I was in the Department of Justice. I have my suspicions as to whether there's any scientific basis for it. But I tell you, a polygraphic examination is a finder of truth. When you have all these wires hooked up to you, and are told, for instance, that one of them measures your sphincter movement. Now talk about an invasion of privacy. But I have seen time and time again how people come forward. In the NSA's case, there's really not very much need for that because we are scrupulous in our compliance with the law. Thank you.
Well, thank all of the panelists. Just such a wealth of knowledge and experience at this table. I wanted to start out with one question and then throw it to the audience. I come to this as really an outside observer on the substance. I guess my question is, I think I'm correct that there's something that all of you have sort of been a subtext of what you've said, but I just want to clarify it, which is that the U.S. system of oversight that you are describing, so 702, the court itself, the existence of inspectors general, and that's, I'm not even paying attention to the congressional oversight, is quite unusual for intelligence operations if we compare ourselves to other countries. We have imposed or adopted quite extensive internal checks, more so than other intelligence agencies throughout the world might experience. Is that a fair factual statement? Is that?
Not according to President Putin.
Okay.
Other than that.
Okay, so if that's, I know that's very broad brush. I guess my question is, those who experience those oversight mechanisms, either subject to an IG investigation when they're in the Justice Department, or those who appear before the court or spend a lot of time with 702 compliance, I think perceive exactly what Dr. Ellard said, which is we are the most regulated intelligence operation in the world. And yet there are many critics who say that's not enough. We have had operations, we have been doing things, we have done things that should not have happened if we had proper oversight. So I don't know, I mean, that's a very fraught question really, but if you have any observations on that you feel you can share on that gap between those who experience the oversight, who feel that we're quite regulated, and those who are critics of what we've done, who say there can't be enough oversight if X has happened.
So let me take the first shot. So so as far as sort of your factual question, my understanding certainly is that we are the only country that has a FISA court, as it were, with this specific court designated to hear national security matters. Most other countries of the world handle their national security collection purely as an executive function. And so it's internal government, what we would, sort of our version of the executive branch functions where they just authorize it. And that's sort of how things are done. So I think our three branches of government oversight is unique and robust. The interesting question that arises then in the context of the past year's debate is when the revelations were made through the unauthorized disclosures, why isn't it that all of the oversight that we're talking about here didn't seem to provide the level of public confidence that those in the process would think that it would have? And President Obama mentioned this in his, I think, sort of statements that he's made over the course of the last year. And I think it's something that folks in government are perhaps struggling with. Because there is so much oversight. And so I think the questions that those who are interested in these issues are now grappling with are, is the oversight that is currently being conducted effective? And so I think one thing we need to think about is we have a very lawyered process right now. I don't think anybody can say that this is an under-lawyered intelligence governance structure. So given that, what is the end result then effective oversight? Are there other metrics that we can be looking at to determine whether the oversight is effective? As a result of all the reviews that have come back and on many of the declassified documents, as Dean Rinskov-Parker mentioned in her remarks, there hasn't been anything that's come out that has shown that there's been sort of deliberate and willful and sort of strategic abuse of the system. So what else can we do then that will sort of provide the public confidence if it's not this internal oversight structure that currently exists?
Do you want to comment?
Sure. I think that we have sort of mixed motives in how we deal with this in the United States. We want to give our intelligence agencies and our law enforcement agencies significant powers to prevent the next terrorist attack, to uncover crime, but we also at the same time are skeptical of them and want to make sure that they're doing it in accordance with the law and with the American public's belief in how they should be handling it. And so I think, for example, in the FBI, they think, and I think it's probably accurate, that they are subject to very intense scrutiny. And we find lots of things where they could have done better, and they sometimes, when we come and say, we're here to help, they kind of roll their eyes, but we are there to help them perform in a better fashion. And they often, I saw it repeatedly when there were powers that were debated as to whether the FBI should have them, whether it was national security letters or others. One of the key things that they brought up was we are subject to very aggressive oversight. We have an aggressive IG. He's going to find something. He's not going to be quiet if he finds something, and therefore you ought to give us those powers. And actually that turned out to be a very effective argument. And it was an argument that was used repeatedly, and it often won the day into as why Congress would be willing to give even more powers to the FBI to prevent the next terrorist attack, while at the same time ensuring that they were doing it in accord with the law and the Constitution and their responsibilities.
Well, the two people who are out of government have commented, so you two choose what you want to say.
I just have a question. I know, and I apologize, I don't recall the details, but one of the disclosed opinions was a very lengthy opinion by then presiding Judge Bates about various incidents of non-compliance under the PRISM program, if I remember. And I assume you know the opinion I'm talking about. What happened? Okay, so he issued that opinion long before it became public. Within your own agency, can you say what
happened as a result of the opinion?
Yeah, when an animal like that gets dropped on your head, what do you do?
A whole lot.
But I think it would be worthwhile to find out.
That was the business records, wasn't it?
Right. Yeah.
Yeah. Well, that's the bulk collection we've been talking about. What's it called within the agency? An end-to-end review. That occasioned. Again, the metaphor is very good. When the anvil dropped on your head, believe me, it gets your attention. And the agency initiated a complete review of that program. And I hesitate to say the results because I just don't know the security rating of it now. But I can tell you it was taken with absolute seriousness. And after I suspect a 6-month review, we came to certain conclusions. Those conclusions were being implemented during the 6-month period, by the way. But I can tell you it led to a lot of restructuring and a lot of very serious thought by a lot of very smart people. And the problem is cured even to the fist, well, as you know, even to the courts, with the court's approval.
Why don't we throw it open to the participants here? And please come to the microphone if you have a question. Go ahead. This is Professor Sinar of the Stanford Law School.
Thank you. So oversight and compliance are only as good as the original rules that are being overseen and complied with. And in some cases, one of the concerns has to do with the scope of the original rules. So even, for example, when Congress directly authorizes a program like the FISA Amendments Act, the scope of the rules that are authorized for intelligence collection, have often been quite broad. And just to make it more concrete, in that case, we're talking about an authority to intercept communications between U.S. persons and, of course, persons located abroad, so long as the deliberate purpose of that targeting is not to target U.S. persons. And if you think about the scope of a statute like that, I read it as potentially authorizing, let's say, the interception of communications between Americans and perhaps everyone located in an entire country abroad. I mean, that kind of surveillance is at least within what I see to be the scope of the text. So my question has to, and just one additional piece of that, the Foreign Intelligence Surveillance Court oversight does not apply to the specific targeting decisions. It's a more high-level oversight of the targeting procedures or minimization procedures that have been put in place. So my question is specifically, what internal oversight, or external for that matter, but is there over the actual targeting decisions? So for instance, given that such a large scope is authorized by the statute, is there anyone who is actually reviewing on questions of, say, proportionality within the government? And what incentive is there ever to say no?
The question is very difficult to answer because you're melding a couple of things, one of which is policy judgments. And we don't make policy judgments. So you're calling for a re-examination of certain authorities. There might be every good reason in the world to have that discussion, but that's not the kind of discussion that you have within, say, an OIG. We look at the law, reasonable interpretation of it, and we determine whether the agency is acting legally and whether it's doing so efficiently and effectively. You're asking for a public policy debate, of which I had nothing against, but that's not going to come within the confines of my office. I'm not going to say to the Director of National Security, I don't think it should be that way. After the Congress has said, this is the way it is.
Right.
Professor Cordero wants to take a shot at it.
Let me try to get it perhaps from a little bit different angle, sort of at the operational level. So first of all, the certifications that are approved under Section 702, which targets the non-U.S. persons reasonably believed to be overseas. So the certifications have some scope, and those are approved by the Attorney General and DNI. So that's where you have sort of at a very broad level a senior policy and national security official who's approving sort of here's how we are going to go about the collection under these authorities. So that's at a high level. Then when you drop down to the operational level, you have targeting decisions that are made by analysts. but you have lots of supervisory levels that are sort of that participate in that process. There always has to be a foreign intelligence purpose to the targeting. So that's sort of one check on, is this an appropriate targeting? There has to be supervisory level, has to be a foreign intelligence purpose. Then there is the Office of Compliance with NSA that's looking to see that all those rules were followed, that, for example, the restriction against reverse targeting. So that's the concept where perhaps a collection would be put on task that targets someone for the sort of subversive purpose of targeting someone here in the U.S. That's not allowed. It's restricted by law. And so, the Office of Compliance and the supervisory levels would be involved in making sure that that is not happening. And then what I was describing earlier is sort of the next level executive branch agency oversight, which is the Department of Justice and the DNI are actually reviewing targeting decisions, making sure that they're in compliance with these broader level authorizations made by the DNI and the AG to make sure that these are sort of appropriate targets under the statute, under these certifications, foreign intelligence purpose. And then on top of that, they're reviewing the reports that get issued as a result of the task collection. So I don't know if that perhaps provides a little bit more at the granular level of what you're interested in.
And one thing I should mention as well is that there are also First Amendment concerns, I believe, in the statute. I cannot remember, but I believe that the statute mandates attention to First Amendment concerns.
We can't predicate selection on the basis of information that's protected by the First Amendment.
Right. And if I can't say, I don't know, but I can imagine that in a situation where that might be apparent, that a FISA court judge is going to pay very close attention to that.
Just the second part of the question, the incentive ever to say no to a decision made by someone else, where would that incentive come from within, when it's not a question of non-compliance with the law, but
I can answer that too, please, because I'm glad that that's a segue into an activity on behalf of the court that very few people are aware of and is of crucial importance, and that is the court employs a cadre of legal advisors. These are people, they're not magistrates, not law clerks. They all have some sort of intelligence agency background, whether in the department where Professor Cordero worked, NSA, CIA, or whatever. So they bring that background with them. They also are lawyers, and they know as much about individually as much about the Foreign Intelligence Surveillance Act and agency law applicable to the agencies, as the court collectively, we as individual judges can. By rule of the court, which again codified practice, at least 7 days before an application is going to be presented to a judge for consideration, it must be submitted to the court for review. The legal advisors review those applications, and there's a great deal. They can talk with the head of the agency, they can talk with the case agent, they can talk with the department lawyer, they can talk with an agency lawyer. They can basically pick up the phone and talk to anybody about it. Does that work? Well, when I started there, by way of background, I had maybe 15 to 20 applications a week. When I was done, I'd go for a day and a half, 2 days. When I got done, I would go for 4 days, have 40 to 60 applications. Routinely and regularly, I'd have a docket numbered, and they'd say, Judge, this case is off docket, that's off docket, this is off docket. And the reason for that was because of the interaction between the legal advisor. It hadn't even come to me, but the court is acting through its legal advisors in a way that I think is very effective. Now, some number of those applications may, whatever it was, got tidied up, and the judge next week or the week after got it. I'm pretty confident that some number of those applications simply never got formally presented. And one of the proposals I didn't get a chance to mention, but that I am making in the public conversation I've been engaged in, is that those instances in which an application is submitted for review in accordance with the rules, but never presented to a judge never sees it, and then is withdrawn, they should also be recorded and published. Because I think the sense of, quote, turn down, that's every bit as much a turn down as if a judge had said no. So I think at least within the court operation itself, there is that layer of pushback, inquiry. I think, and Professor Cordero could probably talk to that more directly from the other end, And also, I want to emphasize, within what's now the National Security Division and with our Office of Intelligence Policy Review, there is no question that the relationship between the lawyers in that Justice Department office and the FBI in particular, but the other agencies, was not necessarily cordial and friendly. They view themselves as gatekeepers. They don't simply, come in and take the application from the FBI and bring it in. By no means. And I don't know, again, the extent to which applications never even get submitted to the court for review by legal advisors and the judge that never show up. But I'm confident, having witnessed this activity for 6 years, that in fact there's a great deal, whatever the motivation may be, there are times in which no is said along the way, and I'm confident myself, though I have less basis for being so, I suppose, that that's what happens within the agencies. Let's keep in mind that the resources everywhere are limited. They've expanded greatly, but they're limited. And think about it. What sense would it make for NSA or FBI or DOD or Department of State to waste resources when in fact there's no basis for doing so? So I think that also, there's self-limiting inbuilt reluctance, as Dean said earlier, to go too close to the edge. There's enough to do that they can do lawfully. I really don't think they have to push, verge into the direction of the unlawful stuff.
We have a question here. Would you introduce yourself?
Sure. I'm Sudha Sethi. I'm a professor at Western New England University. So my question stems from, I think, what Dean Magill posed at the end of the prepared remarks and maybe flowing into what Dr. Ellard just said. So if there's a question of why it is that the vast amounts of oversight that we have are somehow not satisfactory to the public, I'm wondering if the answer comes from the idea that not enough of the oversight pushes on the public policy question itself, right? If the oversight is geared towards making sure that compliance has been effectuated, I think many people would agree, well, that's great. But what is there to kind of push on this question of whether the laws themselves are fundamentally fair and just, whether there has been kind of a proper acknowledgement of kind of democratic values or national values in the creation of these statutes in the first place? And perhaps this goes back to a little bit of what Professor Sinar was just saying, with statutes that are constructed very broadly, where the textual reading of the statute does not always make it clear what it is that is going on operationally, and there's a veil of secrecy around a lot of what happens operationally at the intelligence agencies. If there is no oversight mechanism that really looks towards the public policy aspect of it, does that explain the kind of disjointed nature of the fact that there is a lot of oversight on the one hand, but there's a lot of public dissatisfaction on the other? So I would just appreciate comments on it.
Well, I think that I would be in the same position as the General Counsel and all the other major officers within the NSA if I did not agree with the wisdom of a law. And if my disagreement is significant enough, then I should resign. And perhaps before I did that, I would go to the Senate or House Intelligence and Judiciary Committees and say, are you sure about this? But I don't think that I have the authority as Inspector General to tell the director of the NSA that he should not be doing a legally sanctioned operation. Now, I'm just repeating myself now, but I have my opinions about the wisdom of X, Y, and Z, just as you do. I'm free to express those to the director, and I sometimes have. But that's almost a private thing. It's not as Inspector General of the NSA.
I wonder if you might be in a position to identify where there is space for that policy conversation within.
Sure. A couple spots, and it's interesting to the extent, as I know you have here, as we do as well, to the extent there are students who are interested in sort of going into this area. A lot of the things that I talk about in my class on intelligence reform has to do with sort of distinguishing between your role as a national security lawyer in giving legal advice versus the policy advice that you may at sometimes want to give, and being, as a national security lawyer, being distinctive about knowing when you're communicating to senior leadership, when you're giving your legal advice, and when you're giving your separate policy advice. So with respect to sort of the public policy considerations on intelligence gathering, I think it's important to remember, which I don't think has always sort of been brought to the fore in the recent discussion, which is that it seems obvious, but I'll state it. The intelligence community does not exist to serve itself. It exists to serve policymakers and help them make informed decisions about providing warning to policymakers regarding intelligence threats. And so at the very top level, it is the political leadership in the executive branch that provides direction down through the senior leadership of the intelligence community to what are the priorities and what should be collected in terms of foreign intelligence information. So at senior levels, we have senior leadership of the intelligence community that's supposed to determine priorities, and that determines targeting decisions. And now with the creation of the Director of National Intelligence, that provides sort of a new structure to make that policy process a little bit more clear and provide sort of more direct interaction with the White House. But at the policy level, these decisions are made. And so in the course of the last 10 months, there were certain sort of news reports about certain collections that might be done overseas and targeting different foreign leaders and all that sort of thing. And that discussion sort of took place as if there was no senior level policy review, and senior level political leaders were completely in the dark and had no idea of what could have possibly been going on. And my experience would suggest that, in fact, there is a senior level policy review, and I suspect that in the course of the past 10 months, that policy review has been sort of reviewed and revised and reinvigorated. And so perhaps going forward, based on a number of policy considerations, there may be different targeting decisions made in the future. But I think the suggestion that there is no, at a very high level, sort of policy direction is not sort of the way that it actually works. And so perhaps, I mean, I think that, that sort of falls into the transparency discussion, right? So perhaps one of the remedies to the current situation is that there does need to be more transparency with respect to what that policy process is and what types of accountability there are at the policy levels for the operational work that the intelligence community is conducting.
If I could just talk about that issue as well. I think that's one of the key problems. That is, there is a lot of oversight, but the public doesn't know about that oversight because of the lack of transparency in the oversight. And we tried to be as transparent as we could, even in the Inspector General's Office of the Department of Justice, even with intelligence programs that were highly classified. And we were able to do that and to get reports out on classified programs by making unclassified executive summaries and by pushing the agency very hard on their classification decisions. We heard this morning about the broken classification system, and it is broken. I would see that with the reports that we would give, and we would have to give it to the agency, and say, the FBI, for example, and say, what's classified in this report and what can we say that's not classified? And you give it to one person, and there'd be all sorts of markings classified, and you give it to another person, and it'd be completely different markings. And then they'd give us the report, and we'd say, well, why is this paragraph, why is the whole paragraph classified? What sentences in the paragraph, what words in the paragraph would cause harm to the national security? And then it would cut it down a little more. And then we'd say, why is this sentence classified? And they say, because you can't say that. And we'd look on the internet and we'd find out that the FBI had already testified to that exact sentence, or it was on their website. So, and we'd push them very hard, and we would eventually get a report done after much back and forth that would show what we had done in a classified program. And I think it's very important for oversight entities to do that, to show the public that there is a robust level of oversight, and also to show them what's happening with the programs that are part of their government. So I think that we all could do a better job in pushing for more transparency in the oversight mechanisms.
I would encourage those, particularly in the academic community, who want to, quote, fix FISA, to keep in mind that the Foreign Intelligence Surveillance Act is a compromise between the three branches of government that all three have accepted. And you heard that early on, there was a great deal of opposition. Maybe that's another subject. There was a great deal of opposition within the executive branch when FISA was first enacted. They were not happy with it. And there's a constitutional basis for that unhappiness, because after all, in Congress has told the executive, and the President under Article 2 has exclusive authority to conduct our foreign affairs and protect us against foreign dangers. Read Article 2, the word judge is nowhere in there. But it is said to the executive, for a certain segment of what you do, you can only do it under judicial oversight, the engagement of the third branch. And we do that willingly. So it's a tripartite compromise. Quite candidly, the Supreme Court has never examined FISA. And nobody knows precisely how far the Fourth Amendment goes to control the President's discretion under Article 2, or how far his discretion goes in derogation of the Fourth Amendment. It's constitutional shadowland. I'll be very honest with you. I don't want the John Roberts Court drawn. I don't want a court with Louis Brandeis and William Brennan and William O. Douglas drawing that line. I think we're all better off with that line left entirely fuzzy. My point simply is, those who are seeking to, quote, reform, reconfigure, or reconstruct FISA should keep in mind, push too far and get the executive to the point where they're saying, hell no, we're not going to do that. That may result, arguably, in a determination that the statute itself is unconstitutional. So I'm saying, to some extent, people do the best they can, and we may have, I think we do have about the best we can have. I've made some proposals which are basically tweaks, but rather than sort of a radical restructuring of FISA, which I don't think people are proposing, but I think as you think these things through, I'd ask you to keep that in mind.
So I believe our next panel is supposed to start in 10 minutes, and in order to get a break and start the panel, we have more questions, but no more time, unfortunately. Can you come and ask the panelists after? So please, let's thank the panelists.